Yeah, thank you very much, Cathaoirleach.
15 minutes.
Thank you very much, Cathaoirleach. The bill we're debating at second stage this evening, Cathaoirleach, seeks to amend the Civil Liability Act 1961. It seeks to amend it by putting a new part into that Act. The part that I'm seeking to put into the Act will be a part that will set out a statutory mechanism that will have the effect of prohibiting people from inheriting assets from the estate of persons whom they have killed. We know that in our law at present there is a partial remedy for that problem contained within section 120 of the Succession Act. However, there are other parts, particularly how they relate to joint tenancies held by individuals, that aren't covered at present in statute. Before dealing with the substance of the bill, Cathaoirleach, can I just state at the outset that the Civil Liability Act that was enacted by the Houses of the Oireachtas back in 1961 was a remarkable piece of legislation. It is a very sophisticated piece of legislation that was designed to deal with the issues of civil liability, concurrent wrongdoers, survivorship of actions by people who have died, and also it deals with actions that can be taken by dependents of persons who have died. It was a remarkable piece of legislation. It has been commented upon throughout the legal world as being a piece of legislation of great sophistication. When it was introduced here by the Minister of State at the time, back in 1960, Mr Haughey, it received widespread approval from opposition leaders such as Mr Costello, and Tom O'Higgins at the time was also a member of Dáil Éireann. Part of the reason why it is a piece of legislation of such sophistication is because it was drafted by one of the most preeminent legal academics of the 20th century, Dr Glanville Williams. So I suppose I'm slightly hesitant about introducing legislation that's going to amend this remarkable piece of legislation, but the House and individuals can be rest assured that the only reason and the only way in which the Civil Liability Act has been amended is that this proposed new part is going to be put into it, dealing specifically with the issue of individuals seeking to inherit from the estates of persons whom they have killed. I think it's important to note that really this legislation has its origins in a tragic event that happened in December 2008 when a man brutally killed his wife. Subsequently, in February 2010, that man was convicted of the manslaughter of his wife. Like many married couples in Ireland, they owned their family home as joint tenants. It's important, I suppose, for the purpose of this debate that we're aware of the meaning of a joint tenancy when people own property. If 2 or 3 or 4, or how many people you want, own property as a joint tenant, the most distinctive thing about that ownership is what's referred to as the rule of survivorship. It means that when one of the owners who owns it in equal shares dies, well then his interest or her interest vests in the remaining owners until such time as there's only one person left, and that's referred to as the rule of survivorship. The effect of it in the context of what happened in those tragic events back in 2008 was that after the woman died, her interest in the joint tenancy automatically vested in her husband, who had been convicted of her manslaughter. Now that is wrong. I think everyone in this House would agree that that is wrong, because there's an old principle which says that you should not be able to profit or benefit from your own wrongful act. In that instance, that man was able to benefit or profit from his own wrongful act. What happened after that was that the family of the unfortunate woman brought proceedings before the High Court seeking to disqualify the husband from gaining ownership of the full family home. The case was heard by Ms Justice Lavoy, one of the finest judges we've had in this country, and she recognised, however, that the rule of survivorship, meaning that he was entitled to inherit the joint tenancy, could not be eroded because there was no statutory provision in place to do so. However, she did come up with an ingenious method whereby she stated that the interest which he had in the family home would now be held in trust by the man for the benefit of the wife's family. She also commented, and this is, I suppose, the most important thing and why we're here today, that there needed to be legislation in respect to this issue. the Oireachtas needed to act. Subsequently, the Law Reform Commission produced a report in 2015, which was an excellent report. It did a huge amount of research in respect of this issue. It looked around at different jurisdictions, and it came up with a number of recommendations and proposed statutory amendments. They form the basis of the legislation that I am seeking to introduce here today and to get through second stage. I think it's important to note and to recall what the legislation seeks to do. As I say, it seeks to give effect to the legal principle that no person should be able to benefit from his or her wrongful act. If enacted, it would mean that a person responsible for the murder or the manslaughter or the attempted murder of a joint tenant would have that joint tenancy severed. So in effect, the rule of survivorship would no longer operate. And what would happen thereafter is that the court would be placed in the position where if an application was brought by an interested party, the court would have to determine the amount and value of the offender's interest in the property. So it severs the joint tenancy and it determines what interest, if any, the offender has in the property. The court could turn around and say that person has no interest in it, or it could turn around and say that the individual is entitled to maintain the amount, the 50% of what they owned previously under the joint tenancy, or it could even say something beyond that. But when it comes to making that decision, the court will have to take into account a number of factors, such as whether or not the victim had children, the financial obligations and responsibilities of the offender, the nature of the offence committed by the offender, the gravity of the offence and the extent to which they had, I suppose, displayed a total lack of concern for the victim of the crime. So the court will be at large to consider all the relevant factors in determining what is just and equitable for the purpose of calculating what is the value and amount of the offender's interest in the estate. Can I just briefly take the House through the relevant sections in this proposed part of the legislation? And as I mentioned at the outset, we do at present have on our statute books a prohibition on individuals inheriting from the estate or from the assets of persons whom they have murdered or whom they have killed by way of manslaughter. That's provided in section 121 of the Succession Act 1965. The legislation that we are debating here contains within it a new section, section 46B of the Civil Liability Act, that will reformulate that statutory prohibition contained within section 120 of the Succession Act. It reformulates it by broadening it. At present, the section 120 of the Succession Act wouldn't cover situations such as insurance policies or other forms of assets which don't come within the narrow definition contained within section 127. And under the new proposal, a person convicted of murder, attempted murder or manslaughter would be precluded from taking any share in the property or estate of that other person who is the victim. And I don't think there's any contentious concern about that. It simply reformulates section 120 and makes it broader. I know that there is some contention. I know Minister Dáil, who is here to speak tonight, will note and state that the government have a concern about section 46B(3), which says that the rule should not apply to any person who aids, abets, counsels or procures the commission of an offence. I'm prepared to listen to the government in respect to that. I don't think we're going to fall out in respect of it. I think the priority should be to ensure that we get the substantive part of the legislation enacted. I know that we will have a discussion about it when it gets to committee. I suppose, however, we need to recognise that the Law Reform Commission itself believed that it was inappropriate to include aiding and abetting as an offence that would invoke the operation of this new proposed legislative scheme. I think it's also important to note that under the Criminal Law Act 1997, that Section 7 provides that anyone who aids or abets an indictable offence shall be liable to be indicted, tried and punished as a principal offender. So if you're involved in aiding or abetting a murder, in Ireland you're going to be prosecuted. for aiding and abetting a murder as a principle. So that's the only contentious part in respect of 46B. And the next part, which deals with section 46C, and it implements the recommendations in Chapter 2 of the Law Reform Commission report. What it says is that there's an express statutory prohibition on the offender obtaining the benefit of the right of survivorship, and it states that the joint tenancy between the offender and the victim shall be severed from the date when an offence was committed. That is the absolute central part of this legislation. It's absolutely imperative that the joint tenancy is severed and that the rule of survivorship doesn't operate. Otherwise, the offender is going to find themselves in a position where they are able to inherit the estate of the victim whom they have killed. It then proceeds in section 46C2 to state that where proceedings are brought under this part of the Act, that it shall then be the responsibility of the court to make an order that is just and equitable. The order, as I said earlier, which the court is required to make, is an order determining what is the amount and interest that the offender has in the property. And it may be above or below half of the interest in the property. Under joint tenancy, one of the features of it is that you own property equally. So if there's two people who are joint tenants, will generally be each have a 50% right to it, but the court will determine afterwards whether or not the offender has any entitlement to any share in that estate. And as I said at the outset, a number of factors can be taken into account by the court when it is determining that. The factors that can be taken into account are the contributions, direct or indirect, made by the offender and the victim to the jointly held property. I suppose in the case where, and this will be the case in most circumstances, where the offender and the victim are a married couple, or they're both in the position of parents over the same children, well, in that instance, that factor will have to be taken into account. Also, what will be taken into account is the age and financial needs of any dependent or any children of the victim. That will have to be a very important factor for any court considering the matter. And the court should also take into account the age and financial needs and obligations of the offender. So there's a whole series of factors that the court should take into account when this application is brought. I may not have mentioned, but the people who can bring this application are referred to in the legislation as interested persons. Those interested persons are, the personal representative or executor of the estate of the deceased, people who are entitled to succeed under the estate of the deceased, obviously her dependents or close family members. The other part of the legislation that I suppose is interesting and novel is contained in section 46E, which deals with the civil nature of proceedings under this Act. Obviously, this legislation primarily deals with events that are on, well, at one level, criminal offences. People who kill other people commit criminal offences. It's not always the case, however, that individuals who kill other people are held to account before our criminal courts. Sometimes individuals are prosecuted and they're acquitted, notwithstanding the fact that they may be guilty. On other occasions, there simply isn't enough evidence to prosecute a person for a serious criminal offence such as murder or manslaughter. That happens in this jurisdiction and it happens in every jurisdiction throughout the world. But we need to recall that this legislation comes within the Civil Liability Act. It provides a civil remedy to people who believe that the offender should not be benefiting from the intentional killing performed by that offender on the victim. Consequently, since it's a civil remedy, the civil standard of proof should apply. The civil standard of proof is that something has to be proved on the balance of probabilities. That's different to the criminal standard of proof, which is that it has to be proven beyond all reasonable doubt. There may be occasions when individuals who have killed somebody have not been convicted or have not been prosecuted for what is a crime. However, that should not stop interested persons from bringing applications under this Act to prevent the person whom they regard as the offender from inheriting under the rules of joint tenancy or the rules under the will. It will obviously mean, if the court is satisfied that the individual bringing the application will have put evidence before the court establishing on the balance of probabilities that the person was killed through the intentional act of the other person. That doesn't make them a criminal, but it does hold them civilly liable. Thanks very much, Cathaoirleach, for the time, and I hope to get the support of the House in respect to this legislation.